Hello, I'm Trevor Morrison, Dean of the NYU School of Law, and it is my pleasure to welcome you to the 26th annual Derek Bell Lecture on Race in American Society. The Bell Lecture really is a treasured annual lecture series here at the law school, and it's a special way for us to celebrate and honor Derek Bell's extraordinary legacy in the law. Last year, we celebrated a quarter century of the Bell Lectures, and we are delighted to continue the tradition this year as well. Derek Bell taught at a number of law schools in the course of his storied career, but he ultimately made NYU law his home, and that's something of which we are deeply proud. His leadership as a scholar, as a teacher, and as an activist helped to foster a dialogue, a still continuing dialogue, on the progress or lack of progress with respect to racial reform in the United States. His sense of integrity permeated every phase of his celebrated career, from his early role as the only Black attorney among hundreds of lawyers working at the Civil Rights Division of the United States Department of Justice, to his important role at the NAACP Legal Defense and Education Fund under Thurgood Marshall. Derek's contributions to this law school, to his students, to his colleagues, to legal education, and indeed to the law are legion and far too many to count. As just one small reflection of the deep impact he had on his students here at NYU. In 2012, he posthumously received our Podell Distinguished Teaching Award for his outstanding contributions in the classroom as a professor of constitutional law in particular. Now, the mission of this lecture series is to examine the role of race in American society. And for, as I say, over a quarter century, it has served as an important platform for scholars and activists to share their ideas on racial justice and civil rights. And this year, Robert Chang, professor of law and founding executive director of the Fred T. Korematsu Center on Law and Equality at Seattle University School of Law, will present his Bell Lecture entitled Racial Realism Today. I want to extend my own personal, very warm welcome and thanks to Professor Chang for joining us to present this evening's Bell Lecture. He will be formally introduced in a few minutes by Jason Williamson, class of 2006 at NYU Law, and now the executive director of our Center on Race, Inequality, and the Law. Speaking of that center, the Center on Race, Inequality, and the Law, it, in just a few short years, has become a central hub of work here at the law school on questions of racial equality and justice within the legal system. It is also now the institutional home of the Bell Lecture. In many ways, it builds upon Derek's legacy that he left here at the law school. Would not have been possible without his initial vision. And we're really thrilled about the terrific work that the center is doing. I am grateful for the leadership of the center, the co-faculty directors, Deborah Archer and Vincent Sutherland, as well as, I say, the executive director, Jason Williamson. I'm grateful to all of them for their exceptional work and leadership. I'd like to introduce Derek's widow, Dr. Janet Dewart-Bell, a longtime friend of the law school community, indeed a leader of it. It was Janet who conceived of the Bell Lecture as a 65th birthday present to Derek, and boy, are we glad that she did. Janet's own professional and personal commitment to racial justice, equal rights, education, and communications is exceptional and a true model for our students. Her career has been marked by an enduring dedication to volunteerism and to promoting initiatives that increase diversity and equal rights for all. Please join me in welcoming a great friend to the law school, Dr. Janet Dewart-Bell.
Thank you very much, Dean Morrison, not only for your institutional support as the dean of this great law school, but also for your graciousness and personal support. And let me add, you are, if not the best, one of the best deans on the planet. So I thank you for that, and I lift that up. Derek lived to teach, and teaching kept him alive. For him, it was always students first. It was a mantra in our household. In that universal encyclopedia, His portrait is next to the definition of mentor. For him, there was no greater calling than teacher. It is always gratifying and humbling that students who never met him in person are very much his students, continuing to carry on his work with integrity and dedication. I'd like to acknowledge the three Bell sons, Derek Bell III, Douglas Du Bois Bell, and Carter Robeson Bell. You may note the significance of those names. As the family wit, Carter notes that he has three last names, Carter being in honor of one of Derek's mentors, Robert L. Carter, and his wife, Gloria. The late Judge Carter argued the first Brown v. Board of Education case before the Supreme Court and taught at this law school. By the way, Derek's other mentors were the great civil rights attorney and judge Constance Baker Motley, and of course, Thurgood Marshall. I especially want to lift up the memory of Derek's first wife, a phenomenal woman, Jewel Hairston Bell, who died before Derek and I met. As partners, she and Derek blazed trails together. She set the standard. As Dean Morrison said, 26 years ago, the Bell Lectures started, and there were people who shared a vision with me. You don't do this by yourself. Of course, Judge Robert L. Carter, Paulette Jones Robinson, and Valerie Kavanaugh and her husband, William Kerstetter. Valerie and Bill represent an illustrious and fierce group of social justice and legal advocates, and they are joining us tonight. Also in our village, the Bell Village, is the international lawyer, Alice Young, one of Derek's first students at Harvard. She, along with Harvard professor and Bell student Charles Ogletree, helped endow this series. There have been recent assists from Dr. Kitty Muldoon Steele and Lewis Steele, and from Ted and Nina Wells. And then there is my kitchen cabinet. I have to acknowledge Dr. Naomi Nightingale, Catherine Chadwick, Joyce Johnson, and Lindbergh Porter. Now, Bell Lecturers have been consistently wonderful, stellar academics who have also been social justice advocates. They have that in their DNA. Tonight's tradition, the tradition continues tonight with Robert Chang, who also for me represents Mr. Korematsu, one of my great heroes of all time. So I am so pleased that Bob Chang is able to join us tonight. Let me express deep personal thanks to former Dean and University President John Sexton, a Bell student at Harvard, who championed this series from the beginning, and to his successor, Ricky Revesz. And thanks too to LACA, the Law Alumni of Color Association, and its president, Rafiq Kalim Aden. Thank you so much for your support. And special thanks too to the Office of Development and Alumni Relations for their care and attention to this lecture series, with grateful acknowledgement to Senior Associate Director Kelly Spencer for going way beyond the call of duty to make this series happen. So on behalf of the Bell extended family, I again pledge our continued commitment to this wonderful law school, represented in part by this lecture series and the courtyard bench with a plaque in Derek's honor. I urge you, especially students, to go to that bench, sit there, reflect, plot a little revolution if you want, the good kind, and renew your commitment to the law and social justice. I must thank, as always, the brilliant kind, and humble Vice Dean, Randy Hertz, who gets embarrassed every time I say this, but he became the faculty liaison for the Bell Lecture once Derek died. Students love Randy. I love Randy. As with Derek, Randy Hertz is student focused. I say that he is also student obsessed. He is also truly a gentleman and a scholar. It is my distinct pleasure to introduce Deborah Archer, the new co-director of the Center of Law, Race, Inequality in the Law. She is just terrific. Deborah is a professor of clinical law, and she has so many accomplishments that I would take all night if I actually read all of them, so I'm not going to do that. She's an award-winning scholar and her articles have appeared in numerous publications, and she's also a commentator on national television. She is a graduate of Yale Law School, where she was awarded the Charles G. Alban Prize, and she's a graduate of Smith College. She previously worked as an attorney with the American Civil Liberties Union and the NAACP Legal Defense and Educational Fund, where she litigated in the areas of voting rights, employment discrimination, and school desegregation. She is also former chair of the American Association of Law Schools section on civil rights and the section on minority groups. She previously served as chair of the New York City Civilian Complaint Review Board, the nation's oldest and largest police oversight agency. She is also a phenomenal woman, and she is chair of the ACLU. Deborah is someone that you all should know, and if you don't know, then you should get to know her, because besides being a phenomenal scholar, she is a wonderful person, and I appreciate her being a partner in this journey every day.
Hello, everyone. Thank you, Dr. Bell, for that incredible and overly generous introduction. I am Deborah Archer, and I'm the co-faculty director of the Center on Race, Inequality, and the Law. And it's my pleasure to welcome you to the Derek Bell Lecture and to have this opportunity to tell you just a little bit about the center. Through research, public education, litigation, and advocacy, we work to confront the laws, policies, and practices that oppress and marginalize people of color. W.E.B. Du Bois said that the problem of the 20th century was the problem of the color line, and he was right, of course. And he could have said the same of the American centuries that preceded it, or the 21st century that has succeeded it. Racism has been with us since the country's inception, and in fact, since before we were even a country. It shapes all of our lives, our experiences, and the institutions that govern us. It is unmistakably a part of all that we do, whether we are conscious of it or not. And for a long time, racial justice advocates and legal scholars have been calling for a third reconstruction to address historic and systemic racism and inequality, to create radically different legal frameworks that finally center human dignity and community equity, and that finally and meaningfully address how race, class, and place intersect to shape our lives. And this call is really at the core of the center's work. We work to identify and challenge the architecture of racial inequality, exploring the systems and structures through which racism continues to constrain the life outcomes of some, yet expand the life outcomes of others. And that work includes fighting back against the forces that drive racial segregation and concentrate economic disadvantage in communities of color. It includes overhauling a criminal legal system that has conflated race with criminality and has confused harsh punishment with justice. And it includes addressing the racial justice implications of the technologies at work in the systems that govern our lives. Fundamentally, it means working to highlight and challenge the many ways that our systems and institutions have been infected by racial bias and plagued by inequality, and working to overcome the impact of that infection. And this year, our amazing founding executive director, Vincent Sellerlin, has left the center to join the faculty of NYU Law School and to join me as a co-faculty director. And we've been incredibly lucky to welcome our new Executive Director, Jason Williamson. And Jason comes to the center after serving as the Deputy Director of the ACLU's Criminal Law Reform Project. And we are really lucky to have him. It has been a great honor to work with Jason and to welcome him to the center. And I'm happy now to turn it over to Jason to introduce this year's Derek Bell Lecturer.
Thanks so much, Deborah. I appreciate the warm welcome. So thankful to be here. And thanks to all of you for joining us tonight. We're just so grateful that you're with us. We understand how valuable everyone's time is, and really appreciate you setting aside time to be with us. It is my distinct pleasure to introduce our speaker for tonight, Professor Robert S. Chang, who I had the privilege of meeting for the first time just a few months ago in my new role as Executive Director of the Center. We worked on an amicus brief together, and it did not take long for me to realize how incredibly wise and thoughtful Bob is. And perhaps more importantly, how much he cares about his work and the people with and for whom he advocates each day. So I was thrilled when he accepted our invitation to serve as our lecturer this year, and I think we're all in for a treat. Bob Chang is a professor of law and founder and executive director of the Fred T. Korematsu Center for Law and Equality at Seattle University School of Law. He writes primarily in the area of race and interethnic relations. He's the author of the book Disoriented: Asian Americans, Law, and the Nation State, published in 1999, and another entitled Minority Relations, Intergroup Conflict and Cooperation, published in 2016. Bob has also penned more than 50 articles, essays, and chapters published in leading law reviews and books on critical race theory, Lat Crit theory, and Asian American legal studies. He's currently working on a co-authored book entitled The United States Supreme Court and White Social Dominance, which I'm personally looking forward to reading. As an elected member of the American Law Institute since 2012, Bob has received numerous recognitions for his scholarship and service over the years. He was the 2009 co-recipient of the Clyde Ferguson Award, given by the Minority Group Section of the Association of American Law Schools, which is granted to an outstanding law teacher who, in the course of his or her career, has achieved excellence in the areas of public service, teaching, and scholarship. For his work in Washington in particular, Bob was a co-recipient of the 2014 Charles A. Goldmark Distinguished Service Award from the Legal Foundation of Washington for his leadership role in a statewide task force on race and the criminal punishment system. More recently, in 2018, the Society of American Law Teachers recognized Bob with the M. Shannara Gilbert Human Rights Award for his work as co-counsel on a constitutional challenge to the enactment and enforcement of a facially neutral law that was used to terminate the Mexican American Studies program in the Tucson, Arizona Unified School District. And this year, the ACLU of Washington named him as a co-recipient of the Kathleen Taylor Civil Libertarian Award for his role as co-counsel representing the Black Lives Matter chapter of Seattle-King County in its lawsuit against the city of Seattle for its use of force against people protesting police brutality. Following the murder of George Floyd in the summer of 2020, the statewide task force on race and criminal punishment system was reconvened to produce a 10-year update to its previous 2011 report. Again, under Bob's leadership, the report was presented to the Washington Supreme Court in September 2021, and like the previous report, will be published simultaneously in the Gonzaga Law Review, the Seattle University Law Review, and the Washington Law Review. And finally, for the last several years, Bob has served as co-counsel in 2 cases out of Alaska, challenging the involuntary psychiatric hospitalization and forced psychotropic medication of Native foster children in that state. So, needless to say, Bob remains very busy fighting the good fight, and we're so grateful for his efforts. And so, without further ado, turn it over to Bob.
Thank you, Jason, for the very generous introduction. Give me a moment while I share my slides for today. So I'm so honored to have been invited to deliver this lecture, Racial Realism today. I wish that I could be there with you, but I appreciate technology that allows me to engage with you. I'm speaking from Washington State, from a region that is on occupied Coast Salish land and on the homelands of the Duwamish people. To acknowledge this land is to recognize the history of physical and cultural genocide and settler colonialism, which continues to displace Indigenous people today. So those of us who hold settler privilege in this region must work towards supporting the Duwamish people and all Indigenous people using the various forms of wealth and privilege that we have. So the Korematsu Center, we try to support Indigenous peoples in Washington State through our work in the criminal. And I appreciate Jason's revision. The task force is formally called the Task Force on Race and Washington's Criminal Justice System, but he corrected it to the criminal punishment system. And I saw what you did there, Jason. And so we documented this time the disproportionalities, the disparities that Indigenous people face in Washington State. And the work that I do in Alaska is also work that I do with my students. Even though we do this work, I know that the Korematsu Center and I can do more. On the screen right now is a link to the Duwamish Tribe website. And I love what they have there on their homepage, reminding us that we are still here. So I want to thank Dean Trevor Morrison for his support of this lecture. I want to thank Dr. Janet Duart-Bell for inviting me to deliver it this year. And I also, her work as a scholar is really phenomenal. And I hope that everyone learns more about her work. I also want to thank Professor Deborah Archer for the leadership role that she plays with the Center on Race, Law, and Inequality. And I also want to give a shout out to her and also Vincent Sutherland, who was not pictured here, who in 2019 convened race centers from around the country. And what they did is they recognized that rather than work atomistically in our own institutions, that if we came together, that we could do more. And I'm so appreciative of them bringing us together, which in turn has brought me into conversation with Professor Jason Williamson, the new executive director of the center. And again, thank you very much for the generous introduction. And so Dr. Janet Duart-Bell mentioned the book of the essays from the first 24 in this lecture series. The original title of the book was Carving Out a Humanity, which is actually a phrase that Professor Bell used in 3 articles in 1991, 92, and 93. And in some ways, it's missing the last part of it, which is carving out a humanity for oneself, something that really resonates with me. I regret in some ways that the new press is reissuing the book and they're taking out that part of the title, but that's what it is. The previous Bell lectures, fantastic work, the fantastic words that can be found, a number of them recorded on YouTube and also in this volume, they set the bar very high. And I also want to thank last year's speaker, Professor Gonzalez-Rose, who delivered the first virtual Bell lecture and in some ways showed me how to do this. And so, sorry. Here's the outline of my remarks, starting with acknowledgements, which I've already done. I'm going to speak a little bit about myself and the Korematsu Center. Then I'm going to move to locating the current moment, to talk about the racial project called America and the periodic renewal of the racial compact, differential racialization of other non-whites with special attention to Asian Americans, theorizing race in a multi-group setting, and then what Arizona's 2010 Ethnic Studies Man can teach us about today's classroom battles. And then I'm going to close returning to this notion of what does racial realism look like today? And so I want to begin in some ways by talking about myself, because I really do believe that it is important to know where somebody comes from in terms of the work that they do. What are the things that have led them to where they are now in terms of what they say and in terms of what they do. So I was born in Korea. And I say Korea, and I don't say South Korea, even though it was formerly South Korea. And I say that in part as a way to remind people of the violence that the superpowers did in using territories and peoples as pawns, creating division where no division existed before. My family came to the United States in 1970. And what's important about recognizing that my family came in 1970 is that we came after so many of the earlier civil rights struggles, the things that made me speaking before you possible. And I want to recognize that debt. I think it's something that many post-1965 Asian immigrants and their families may not fully appreciate. And that's actually part of the work that I do, trying to educate people about this. Because of the way that immigration restrictions operated, my father initially, and I want to recognize another connection, my father initially came as a visiting scholar to Howard University. They gave him an opportunity to come here to study for a year. I'm not exactly sure what he saw in the late 1960s. One of the stories he talks about is the burning of the ROTC building at Howard University. But he saw enough that he wanted to bring his family here to make a new start. Because of the way that immigration restrictions operated, he needed to figure out some way to come under the professional classification. And he figured out that there was a need for librarians. And so he became a librarian, and that was how he got a green card. And that's how we ended up in Granville, Ohio, where Denison University is, a town that is almost completely white, very few people of color. And I want to tell you a little bit about a formative experience there during sixth grade. There were really two of them. In one of them, the class in my English class was reading West Side Story. And for a portion of it, students were assigned parts to read. And I'm not making this up, but I was assigned the part of Chino. I was the only one who looked like that in my class. Sometime after that, and I don't think that it was prompted by that, but my classmates engaged in a month-long festival of name calling, the things that people who look like me are usually called. And it just went on and on and on. And finally, the day that it stopped was the day that a student called me the N-word. And I remember the curl of his lip as he hurled that slur at me. In some ways, the worst thing that he could think of to call a person. And my sixth grade me, in some ways, wanted to respond by saying, well, but I'm not that. But in some ways, I was that. I was the other in their midst. And I would never claim to know what it is like to be African-American in the United States, but I do know what it is like to be other. And in some ways, I start there in terms of that story, because when I'm trying to engage with someone about issues of race or inequality or discrimination, I try to invite them to think about moments in their lives when they have been an other. And most people can find that place. And finding that place allows, in some ways, us to find some common ground where then we can continue our engagement. Now, following that, I actually sort of shied away from everything dealing with race because in some ways that was too raw. And in some ways I embraced the notion of being a model minority, trying to protect myself through the world of achievement. And that's what I did through college and into law school. And then things changed. And here, When and Where I Enter, that's the title of a book by Paula Giddings, When and Where I Enter, The Impact of Black Women on Race and Sex in America. And she's quoting Anna Julia Cooper, who said, "Only the Black woman can say when and where I enter in the quiet, undisputed dignity of my womanhood, without violence and without suing or special patronage. Then and there, the whole Negro race enters with me. And so what happened was I got exposed to feminist theory, and especially the writings of women of color. And so writings by Gloria Hull, the book, All the Women Are White, All the Blacks Are Men, but Some of Us Are Brave. And then This Bridge Called My Back, a collection of essays by Sherry Moraga and Gloria Anzaldúa. And it was then through feminist theory that I started to gain a language for thinking about the earlier experiences that I had had, and really the ongoing experiences with discrimination that I faced. And then critical race theory. I was fortunate enough at the school that I attended that they had this annual event, at least for a couple of years, called the Frontiers of Legal Thought. And it was there that I heard the words of Angela Harris, and Professor Derek Bell, and Jerome Culp, and Patricia Williams. And that's what really altered the trajectory of my life and my career. And so one of the things that I worked on was motivated, wanted to write about was what I thought was a gap in terms of traditional civil rights work and critical race theory. And so talking about this idea of toward an Asian American legal scholarship, critical race theory, post-structuralism, and narrative space. And it was that gave me a voice. And that article begins with a prelude of the different voices in which I speak. I've been most comfortable with the one called silence. Silence allowed me to escape notice when I was a child. I could become invisible and hence safe. Yet now I find myself leaving the safety of my silence, and I wonder if this is wise. And then I recount some instances where I faced discrimination. These are the thoughts that intrude. I try to push them away. I try to silence them, but I am tired of silence. And so I raise my voice. And it's really feminist theory and critical race theory that brought me to that space. And I realized there's a slide that I've somehow skipped, which is the acknowledgement of the role that Professor Bell played early on in my career. So he gave me encouragement when I was a legal writing instructor trying to get a tenure track position where I could more securely speak, write, and do the things that I wanted to do. And one of the things that I so appreciated about Professor Bell is that he treated every person as an individual. Like, he saw their humanity. In some ways, it made the book signing go on for a very long time because he would ask each person about themselves. He asked me about what I was doing, my aspirations. And I was talking about that first article that I was trying to complete. And his words to Bob Chang, best wishes with Asian Studies and American Law. It gave me the support that I needed, the encouragement to complete the article, which then actually allowed me to gain a more secure place in the legal academy. It eventually led me to found the Fred D. Korematsu Center for Law and Equality. And what a privilege it is to be gifted with or entrusted by the family to honor and advance Fred's legacy. And for those of you who are not familiar with Fred Korematsu's story, he was one of the men who resisted the incarceration during World War II and took his case all the way up to the US Supreme Court. He said no, and there was a real power in an ordinary individual saying no, even though he lost then. And then in the 1980s, when he was approached to see if he would be willing to bring his case back to try to overcome his wartime conviction, to help expose what the government attorneys had done in keeping information from the US Supreme Court, he didn't hesitate. He said yes. And then the other thing that Fred Korematsu did was reminded us of the importance of not just being for yourself. And so following 9/11, he stood with those who came under additional scrutiny, harassment, and he said, this is not right. And so this is what we try to do in the center. We think about things, we talk about things, and then we also do things or try to do things. Now, shifting a little bit now, locating the current moment within which we're operating. What an auspicious time to be asked to deliver this lecture during a time when there's the attack on CRT and history in public education, during a time when there is this attack on democracy, and during the never-ending police brutality against Black, Brown, and Indigenous bodies. And then layer onto that the pandemic. And here are some observations that I want to carry through in my talk. I want to talk about the intensification of white racial identity. I want to talk about the sustainment of Black racial identity, and then about the intensification of Pan-Asian American racial identity, and in some ways, a shift in the self-identification of Hispanics, reflecting the ongoing process, of racialization. And so, in telling the story, in terms of thinking about these observations, I'm going to go way back in time. I hope that I can please indulge me as I take us back to the colonial era to talk about the racial project called America that is underwritten by law. This brilliant book that I always go back to by Judge A. Leon Higginbotham Jr. in The Matter of Color, where he talks about things like the case of John Punch in 1640, African indentured servant who ran away with two other indentured servants who were not African, who were white. They were captured. The two white indentured servants get 4 years added to their term of servitude, and John Punch gets lifetime servitude. And Judge Higginbotham goes through the different ways that indentured servitude turned into lifetime servitude, that turned into hereditary servitude, slavery. And one of the sort of key points in terms of that process and in terms of the construction of a white racial identity took place after Bacon's Rebellion in 1676. And in Bacon's Rebellion, 6,000 European bondsmen joined with 2,000 African bondsmen in revolt, burning Jamestown. And even though the revolt was put down, what happened was that the ruling elite were frightened. They were concerned that the lower social strata might rise up and endanger the physical safety, material wealth, and political power that they had. And so they engaged more systematically in developing differential privilege. So privileges that white, even indentured servants got, and disabilities that affected Black indentured servants and Black slaves, marking in some ways by giving this different privilege, stratification, which helps to produce the different groups. And then in some ways, when we think about the invention of the white race during this time, this wonderful book by Theodore Allen, he talks about how those laws that gave this differential privilege to white persons, well, there was a requirement that parish clerks or church wardens, once each spring and fall, at the close of Sunday service, should read these laws in full to the congregants. Sheriffs were ordered to have the same done at the courthouse door at the June or July term of the court. And so there was this system put into place to remind white persons of the privilege they got, which is part of producing this category, this white race. So this gets carried forward in the Racial Compact, also known as the original Constitution. Sorry, I'm having issues with. All right, so, and then what happens is that you need periodic renewal of the Racial Compact. And so following the Civil War, when you have Reconstruction, you have the 13th, 14th, and 15th Amendments. You have various civil rights laws that are passed that try to recognize and protect the rights of the newly freed African Americans. But Reconstruction prompts backlash, and it prompts the redemption of the South. It prompts things like the 1877 Hayes-Tilden Compromise, when Union troops are withdrawn from the South. And then you get the court involved with cases like the civil rights cases, and then carried forward to Plessy versus Ferguson. Now, during this period, there were attempts sometimes to organize the lower strata. And W.E.B. Du Bois, this is at page 623 in this book, talks about the psychological wages of whiteness. And he describes how it must be remembered that the white group of laborers, while they received a low wage, were compensated in part by a sort of public and psychological wage. On the other hand, in the same way, the Negro was subject to public insult and was compelled almost continuously to submit to various badges of inferiority. The result of this was that the wages of both classes could be kept low, the whites fearing to be supplanted by Negro labor, and the Negroes always being threatened by the substitution of white labor. And importantly, in a way that was different, I think, in some ways from that earlier period where whites are just told about the advantages that they get. Because Reconstruction and the freeing of the former slaves was thought to be an advancement of Negro rights, white labor saw in every advance of Negroes a threat to their racial prerogatives. And so it's not just a recognition of the benefits, but this idea of threat that fosters division, all connected with the public and psychological wages associated with whiteness. And so W.E.B. Du Bois, brilliant essay, first published in 1910 in The Independent, and then revised for publication in a collection of his work, The Souls of White Folk. And he talks about the discovery of personal whiteness among the world's people as a very modern thing, a 19th and 20th century matter indeed. The historian Nell Irvin Painter, in a wonderful book published in 2010, The History of White People, also engages with this, but also reminds us, and this is the portion that I have highlighted on this slide, the notion of American whiteness will continue to evolve as it has since the creation of the American Republic. And so it's this notion that race is not static, it's continuing to evolve. And in some ways, this idea or thesis of the intensification of white racial identity occurring at certain moments during history, and in a way that I think is happening now, that I will return to as my talk develops. Now, primarily so far, we've been talking about Black-white racialization, Black-white racial paradigm, but you have differential racialization that occurs with regard to other non-whites. And so, and I've violated all the rules of PowerPoint with all of the text here, but this is really just things to remind me of things to talk about. With regard to indigenous peoples in America, you have different phases: extermination and dislocation, removal and relocation, allotment and assimilation, termination and relocation, and then a period of self-determination. But overlaid upon that is the way that blood quantum rules begin to operate in ways that are inconsistent actually with earlier tribal identification. And this is really just being presented in very summary form because I'm going to focus on Asian Americans. But with regard to Latinas and Latinos, you have conquest and incorporation with the Treaty of Guadalupe Hidalgo resolving the US-Mexican War. And then you have this thing that might be described as accidental whiteness that occurs because of the product of this 1897 case decided in the Western District of Texas, In re Rodriguez. And in that case, a person who, Ricardo Rodriguez, a person who claims to be of full Mexican blood, does not claim to be of African descent or of Indian descent, seeks to become naturalized. And the court is trying to figure out what to do with this person. They say, well, he's pretty clearly not white. And at that time, the only people who could become naturalized by, according to the naturalization statute at the time, were white people and aliens of African nativity and persons of African descent, and he's not those things. And they were pretty sure he was ethnographically not white, but based on the Treaty of Guadalupe Hidalgo, they decided that because the earlier Mexicans were allowed to become US citizens, that they were in some ways formally legally white, at least for purposes of naturalization. Now, this accidental whiteness got carried forward in some ways and embraced in the early period when the League of United Latin American Citizens was trying to advance the rights of Mexican Americans in the US. Ariela Gross has this great treatment of this in an article talking about Texas Mexicans. And she talks about what might be described as the other white strategy. George Martinez also has a great article on legal indeterminacy that looks at the cases. And the results were mixed. Sometimes they could use formal legal whiteness to overcome discrimination, but sometimes they lost those cases. And then cynically, the other white strategy ended up backfiring. As an example, after Brown versus Board of Education, there were some school districts, for example, in Corpus Christi, that decided that they would desegregate by putting Mexicans together with African Americans. And so they would say, we are desegregating because the Mexicans are formally legally white. That changed after a period of time, and I think it had to do with the way that ascriptive treatment of non-Anglos operated. Now, I want to shift now to talk about Asian Americans, and I want to have a brief digression on terms. I'm not including here Pacific Islanders, Native Hawaiians and Pacific Islanders, and it's not an intent to exclude, but it's intended to be honest in terms of what I'm talking about with regard to Asian Americans. Because when you aggregate everybody into one category, you lose some things. So as an example, this time around with regard to the Race and Washington's Criminal Punishment System Task Force, we disaggregated the treatment of Native Hawaiians and Pacific Islanders where we could. And we observed things that would have been erased if we had just talked about Asian Pacific Americans lumped together. And this is that, for example, just throwing out one figure, Native Hawaiians and other Pacific Islanders are 3.3 times more likely to be killed by police than a non-Hispanic white person. And the differences are also geographic, so that in King County, the county in which I live, the most populous county in Washington state, that number jumps up to 6.6 times. And so it's important to think about when you aggregate and when you disaggregate, to think about the similarities and the differences. And then the themes that I'm going to talk about include the way that, with regard to Asian Americans, the way that we are regarded as always forever foreign, the lumping that operates, and then the way that the model minority myth operates as a way to obfuscate and stratify. For those unfamiliar with the origin of the model minority myth, it's attributed to demographer William Peterson. I believe he's a demographer at Berkeley. In an influential New York Times article published in the magazine in 1966, he talked about the Japanese Americans who, despite facing tremendous discrimination, were pulling themselves up by their bootstraps and presenting Japanese Americans as a model to be emulated. But it was intended to blame other minorities who were not able to pull themselves up by their bootstraps. And it also has a way of obfuscating the tremendous differences that exist even within Asian American communities, extreme poverty that also exists. So there we go. A chapter that people may be less familiar with is how do you racialize this new group within the topography of the United States? And so this is from a TED-Ed animated video. And I got so excited when at the beginning of the pandemic, TED-Ed contacted me about doing this. And I was like, oh, I got invited to do a TED Talk. And then they quickly tell me, no, we want you to write the script for an animated video. And you don't even get to speak. It's a voice actor who speaks. But I was so excited to do this. It already has over 550,000 views, which allows this lesson to reach more people. And it's talking about the way that the Chinese Exclusion Act operated and the way that the plenary power doctrine came to be recognized in Xi Jinping versus the United States. But the story begins with an earlier case, People versus Hall, 1854 case by the California Supreme Court. And in a murder trial, a white man, George Hall, was convicted of killing a Chinese immigrant laborer. His name was Ling Sing. Ling Sing's name doesn't appear in the opinion. But George Hall challenged his conviction to the California Supreme Court, saying that the court below improperly admitted testimony by Chinese witnesses. And so at the time, the statute said no Black or mulatto person or Indian shall be allowed to give evidence in favor of or against a white man. But then the question is, well, what do you do with somebody of the Mongolian race? And so the court there, exercising word magic, said, well, based on ethnographic theory at the time, Indians, American Indians, came over from Asia. And so Indian here includes people from Asia. And so that testimony should be excluded. But then they also talked about the way that Black operated as this catch-all category, encompassing really all non-whites. And obviously, you would want to protect white people, including George Hall, from the testimony of non-white people. And so his conviction was overturned. There we go. There's just a little bit of a lag. So anyway, when we're thinking about the treatment of Asian Americans on the process of what might be described as ascriptive racialization, the techniques that were developed and used against the Chinese, violence, discrimination in economic spheres, discrimination in social civic spheres, discrimination in education, discrimination in family formation, exclusion, literal, including deportation, and exclusion with regard to naturalization. These techniques developed and used against the Chinese were then transferred and adopted to subsequent Asian immigrant groups. Because when Chinese exclusion was put into place by the 1882 Chinese Exclusion Act, well, capital still has a thirst for cheap labor. So they went on to another group. And the group that came after the Chinese were Japanese immigrant laborers. The immigration of Japanese immigrant laborers was then seen as a threat, at least politically. And so the immigration of Japanese laborers was stopped by the 1907-1908 so-called gentleman's agreement. Again, capital has a thirst for cheap labor. They turned to South Asians after that. The immigration of South Asians then led to the similar patterns, which then led to the 1917 Asiatic Barred Zone Act. But rather than naming South Asians by name, it just denoted this huge territory, including by longitude and latitude of Asia, where people would not be admitted to the United States. Then following the exclusion of South Asians, you then had Filipinos come in, answering again capital's thirst for cheap labor. So we have ascriptive racialization. We have the way that the Asian American racial subject is created. And that's how, even though there are obviously tremendous differences between these different groups, there is this cognizable category, the Asian American racial subject. And there are differences when we think about colonization with Hawaii, the Philippines, in Philippines, they're in here twice. American Samoa and Northern Marianas Islands, there are differences, which is why I'm talking about Asian Americans and not something that includes right now, the racialization of Native Hawaiians and other Pacific Islanders. Now, being mindful of time, I'm going to skip now to at least explaining in some ways a doctrinal difference that is usually not taught in con law classes, and I think it should be. And so we're told in con law, one of the stories is the story about judicial review as a way to check the excesses of the executive and the legislature, of the other branches. But it doesn't operate that way with regard to policing the border. And this comes out in the case of Che Chan-ping versus the United States. And so if therefore the government of the United States through its legislative department considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, their exclusion is not to be stayed because at the time there are no actual hostilities with the nation of which the foreigners are subject. This determination is conclusive upon the judiciary. This is a deformity in terms of the way the judicial review is supposed to operate. The plenary power doctrine is inconsistent with the traditional narrative of the way that the courts again, check the excesses of the executive and the legislature. And because of this, all manner of mischief is made possible. But this is another way then that we might describe it as Asian American exceptionalism produces this deformity, but which also operates to ascriptively racialize and produce the Asian American legal subject. And so getting back to thinking about how this operates, we think about the early efforts in terms of racialization, People versus Hall. Something I didn't talk about earlier was the 1875 Page Act, which was directed at keeping Chinese women from immigrating as a way to prevent family formation and the development of stable intergenerational Chinese American communities in the United States. The 1882 Chinese Exclusion Act, which didn't just stop the entry of Chinese laborers, but also by statute said Chinese persons could not become naturalized citizens. Spoke already about the Gentleman's Agreement, the 1917 Barred Zone Act. Then in 1924, you have the Immigration Act, which consolidates, which completes Asian exclusion by saying that aliens ineligible for citizenship cannot enter into this country. And the 1934 Tidings-McDuffie Act closed a loophole with regard to the entry of Filipinos because the Philippines was a colony of the US, so they were able to come in as US nationals. The 1934 Act formally gave the Philippines independence, although it wouldn't happen for 10 more years, but it reclassified them so they could no longer come in as US nationals. All of this was underwritten and overridden by violence. In terms of exclusion from the national body, naturalization, the 1798 Naturalization Act, you get the 14th Amendment changing things with regard to the citizenship clause, at least for those who are born or naturalized. You get the Naturalization Act of 1870, which extends naturalization rights to aliens of African nativity or persons of African descent. And then we still have the question, well, what about some other groups? Ozawa versus the United States in 1922, Japanese immigrant comes to the court and says, I want to naturalize, and actually presents his skin as evidence. He claims whiteness. Court there says, no, I know this, we know the statute says white persons. It doesn't mean literally white people. We know that there are white people who are darker than you. We think that it means Caucasian. And then the following year, United States versus Thind, you get a South Asian man who the court has to recognize as, based on the ethnographic theory at the time, as being of Aryan ancestry. And so he's Caucasian, and he says, you said white equals Caucasian. And the court says, we know we said that, but you're brown. Obviously, white should not be thought to include you, and retreated in some ways from scientific racial categories. Ian Haney Lopez has provided an excellent treatment of this in his early book in the 1990s, White by Law. And then using this category, you have all manner of discrimination that operates. And so again, ascriptive discrimination produces the Asian American subject. I'm going to skip this slide. There's a story in terms of piecemeal incorporation. The Chinese are allowed to become naturalized and become US citizens in 1943. 1946, Filipinos and South Asians. 1952, finally, the racial bar to naturalization is lifted, but tiny quotas remain in place. For many countries, limited to 100 people per year. In 1965, they finally removed these tiny quotas. I just chose 1963, but it could have been any other year. But when we think about why America looks the way that it does, it's not accidental, it is by design. So the annual quota for Europe in 1963 was 103,000 people. For all of Asia, and these are annual numbers, Asia was 2,000 some, and Africa, it was 1,000 some. There was a deliberate construction and maintenance of this country as a white country. And so then, how do we theorize race in a multi-group setting? All of a sudden it becomes messy. Lisa Ikamoto wrote this great article following when LA burned after the police officers who had beaten Rodney King were acquitted. And she talks about this idea of racial positioning. And this is something that I want to explore in a little bit more detail. And so when we're thinking about race, sometimes we think about racial dyads. And there are rhetorical and legal techniques that operate here. You could have white, non-white. In some ways, that's a story that plays out in People versus Hall. You could also have black, non-black. And this was the plaintiff's litigation strategy in Gong Lum versus Rice. Martha Lum was excluded after showing up the first day, was then excluded from the white school that she had begun attending. And her father, on her behalf, sued to try to get her admitted. Now, the problem though is that it was an as-applied challenge. It actually, if successful, would have reinforced segregation. And the litigation strategy was to say, well, we're not Black, and because we're not Black, you can't make us go to the Black school. The court said no and really treated the categories as white, non-white. So when we think about racial hierarchies, sometimes we think about a top and a bottom. And thinking about hierarchies allows us to think about the way the power dynamics operate. And the strategy then becomes, well, if you're trying to improve your position, so you're a new group that comes in. So let's say that you're the Irish, and initially the Irish are not treated as being white. Well, the strategy becomes one of distancing yourself from Black people and associating yourselves with whiteness. And so as an example of this, the Irish, and if I have the story right, in Baltimore, agitated and said, let's make this an all-white waterfront as a way to displace Black stevedores who were operating to offload ships in the harbor. So it's a claim of whiteness, a distancing from Blackness. And race hierarchies like this are useful, but I think that it doesn't quite capture things in terms of the way that multiple groups operate. And some of this work is developed with my occasional co-authors, Jerome Culp and Neil Gotanda. And when we're thinking about this, there's a way that this idea of racial triangulation operates. Earlier, I mentioned the case of Plessy versus Ferguson, the case that made separate but equal sound, constitutional doctrine. And we have the dissent by Justice John Marshall Harlan. Our Constitution is colorblind. And sometimes he's celebrated as this civil rights hero ahead of his time. I want to remind folks, though, of what else he said in the opinion, something that is often not included in con law casebooks. And it's this pronouncement of white racial superiority that he announces in the opinion. And then the other part that is often not included is the idea of triangulation. And in terms of thinking about triangulation, what we have, part of what Justice Harlan was upset about was that a Chinese person who we don't even allow to enter into this country or to become a citizen is allowed to sit in the same car as a white person, whereas a Black Union veteran, it has to sit in the segregated car. So we see triangulation in some ways where whites and Blacks are put on a more even terrain in terms of being insiders, with the true outsiders being the Asian Americans in this story. The political scientist Claire Jean Kim developed this idea of the racial triangulation of Asian Americans in a very powerful way. And when we think about this, we can think about deployments. We can think about the way that Asian Americans are then described as a model minority, in some ways offer the privilege that comes with that, but the privilege comes at the expense of Black people and Latinas and Latinos. Or when immigration reforms were being debated in the 1980s, there was an attempt to secure the support of African Americans, Black persons. And so this notion of Black persons as American, but then who loses in that deployment? Asian Americans and Latinas and Latinos as the true outsiders, the non-Americans. We can also think about counter deployments, the story of the Japanese-Mexican Labor Association and the Oxnard strike of 1903. After that strike, the JMLA sought membership in the AFL, and it was conditionally granted in a letter by Samuel Gompers, but subject to Asians being excluded. And when offered this privilege, the Mexican-American worker said no. And then Ralph Lazo, a Mexican-American teenager, spent years in a Japanese incarceration camp, and for the win, right? So when privilege is offered to you, what will you do? And that's a question that all of us face. Now, I'm not going to talk about, the work of C. Vann Woodward. People disagree in some ways with his thesis there, but he did periodize things in a very important way in terms of conceptualizing the notion of the second Reconstruction. And earlier, Professor Archer talked about the third Reconstruction. Well, the second Reconstruction, which takes the form of civil rights struggles, including the litigation that led to Brown versus Board of Education, and also the 1964 Civil Rights Act, 64, 65, and 68, advanced the rights of racial minorities, absolutely. But it was met with backlash, this idea of a second redemption. This is my good friend and occasional co-author, Adrian Davis, who introduced me to the idea of redemption. And here, when I'm talking about redemption, I'm not talking about it in the way that I think the book of the Bell Lectures, Race, Rights, and Redemption, but redemption where the Southern body is redeemed by this, initially by the Southern wing of the Democratic Party. And so redemption in some ways is here in this context is again the rollback of the advances of the civil rights movement, leading some to think that we are now in a post-civil rights era. And so then finally we get to the notion of racial realism that Professor Bell advances. And it's dark in some ways, this notion that Black people will never achieve equality in this country. And he calls this racial realism. This mindset or philosophy requires us to acknowledge the permanence of our subordinate status. But he says that the acknowledgement enables us to avoid despair and frees us to imagine and implement racial strategies that can bring fulfillment and even triumph. And so in some ways, he's saying, if you accept this, then it pushes us to think about new directions. And he gives us hard truths. So Serving Two Masters, where he reminds us that sometimes civil rights lawyers forget the goal, that in some ways that it's not just formal equality achieved through desegregation, but what is it that the clients want? They want educational equity. They want educational opportunities for their children. And then Brown versus Board of Education and the interest convergence dilemma, telling us that this notion in some ways of placing Brown as part of the story of the self-correcting mechanism that operates successfully in the US is actually not quite right, that there are other ways that we need to understand what occurred, which can then inform us in terms of what we need to do from here. This gets me to in some ways, the case study, what happened in Arizona can teach us in some ways about today's classroom battles, the attacks on CRT and history that is going on in state legislatures, but is also happening at the local level with regard to school boards. And so this is a law that was passed in 2010 in Arizona, which prohibited these concepts from being included in courses or classes, promote the overthrow of the United States government, promote resentment toward a race or class of people, are designed primarily for pupils of a particular ethnic group, or advocate solidarity instead of the treatment of pupils as individuals. And so located then in the context of Tucson and its public schools, the first colored school opens in 1913 in Tucson, and then Mexican schools operate, and they're legal if students are segregated for pedagogical reasons. And the pedagogical reason that is usually put forward is, language ability, regardless of whether or not they had any trouble in terms of English language learning. You eventually had desegregation cases filed in 1974. The named plaintiffs, Fisher representing the African-American student class, Mendoza representing the Mexican-American student class. 1978, victory in some ways. And then in 1998, TUSD, in response to another lawsuit, establishes the Hispanic Studies Department. It grows, it blossoms, and it actually takes students with low earlier student success, and it increases their standardized test scores, and it increases their graduation rates. But then we have backlash. Dolores Huerta, in a speech at Tucson Unified School District, says, in response to a question about the immigration bills that were floating around in the Arizona legislature, the Republicans hate Latinos. The state superintendent of public instruction, a Republican, sends his deputy, Margaret Garcia Dugan, and her speech is intended to communicate to the students that she, Margaret Garcia Dugan, is Republican, she's Latina, and she doesn't hate herself. The students are told that they are not able to engage with the speaker, and so they protest by placing tape over their mouths, their silence. This causes an immediate backlash. It causes the law to be passed, and eventually Tucson Unified School District to be found in violation. Now, this is a picture that we included as some of our proposed exhibits before the trial in 2017. We actually didn't get it admitted formally, but if you're going to ban books, don't say that on the cover. And these are the books that were specifically banned, but there was much more material that was removed from the classrooms because all of the Mexican American Studies materials had to be removed. And so when we think about this, what do you lose when these things are taken from the classrooms? And on the first day of trial, testimony from Dr. Curtis Acosta, who was one of the teachers in the former MAS program, gave testimony that I think influenced the judge, talked about windows and mirrors. The materials that he uses in his Latino literature class present windows onto the world so that the students can see the full panoply of diversity. They also operate as mirrors so the students can see themselves in the materials in a way that makes education something very different. When those windows are covered up and the mirrors are covered up, what happens? And so these are three student plaintiffs that I had the privilege of representing. Nico Dominguez was a senior when school administrators came into his American history, Mexican American perspectives class and boxed up materials. Karina Lopez was a 10th grader who had signed up to take Latino literature and American history, Mexican American perspectives. She was not able to take those classes. Maya Arce was in 8th grade and intended to take those classes and was unable to, and had to attend Saturday or Sunday classes at a community college to get the materials. What happens when those windows onto the world and the mirrors within which you see yourself are covered up and real harm takes place? And so I'm going to skip now some of the more technical legal things in terms of the right to receive information and ideas, which in some ways is a weak right because it doesn't entitle you to any particular materials or any particular ideas. it just means that this right cannot be unconstitutionally infringed. And so in some ways, that is what we were forced or left to argue in this case. It was a roller coaster. Most of the case lost at summary judgment in 2012. And then a successful appeal to the Ninth Circuit, and then remand to trial. We were before Judge A. Wallace Tashima, and our expert witnesses were Mexican-American scholars presenting key facts that helped us to persuade the judge that the law was both enacted and enforced in violation of both the 14th and the First Amendments. Now, our clients eventually prevailed, but at what cost? And this is the sort of the thing that I find most tragic about this, which is, although the law was then stricken, it did not require, and we could not ask the court to reinstitute the Mexican-American Studies program. That's a matter of local politics with regard to the school board. We did take away the cloud of enforcement, and I think that was a very important victory symbolically. And in speaking with teachers and students, it was deeply meaningful to have a multiracial team of lawyers from around the country working on this case. And so this returns us now, and I'm almost done. I think I'm nearly at the end of time. But this reminded me of a late chapter in W.E.B. Du Bois's book, The Propaganda of History, how the facts of American history have in the last half century been falsified because the nation was ashamed. We see this happening again with regard to the attack on the 1619 Project, the new origin story, which is found to be very threatening. We see the renewed effort to crush the teaching of the truth about history. And this is a map of the places where critical race theory is under attack. But all of this, in addition to trying to control what is being taught, is also part of dog whistle politics that is leading to an intensification of a certain form of white racial identity. And the way that people don't know what CRT is, but they're against it, it's mobilizing certain white parents and students and other people in a way that is divisive, which reminds us of the earlier moments where these things, teaching the truth about history, is thought as an affront, an insult to white people, which then changes the way that they engage in politics. Dog whistle politics, in the interest of time, I will not go through this story. The Southern Strategy by Richard Milhouse Nixon, Ronald Reagan launching his national campaign in the county where the three civil rights workers were killed, and then Bush, the infamous Willie Horton ad. And so this gets us to a deep appreciation for the work being done by Kimberly Crenshaw and the African American Policy Forum, where they recognize that it's not just on the legal terrain that we need to fight in terms of the litigation. And I think that litigation is critical, but we need to win in the messaging. We need to overcome the dog whistle politics. And when, at the end of the day, we're sometimes left with the question that James Baldwin posed. You wonder, what is your role in this country? And then the way that Professor Bell, carving out a humanity for oneself, how do we go about doing this? And then when we think about the long game, how do we come to participate in the struggles of those who are not us? How do we come to see ourselves in others? How do we see others in ourselves? And the message I want to leave everybody with is the importance of learning your history, to learn the history of those who are not you. And then at the end of the day, it's on you. And I'm so inspired by the work of educators and advocates like Charles Hamilton Houston, and also Professor Derek Bell, and the generations of people that they have taught and influenced. And even though racial realism, the article that Professor Bell wrote in 1992, feels really dark, he talked about triumph. He talked about the possibilities of redemption. And so it's there that I want to end as we think about each of us. What are the possibilities of redemption? Not in the sense of the earlier way that Reconstruction and the Second Reconstruction were ended, but rather true redemption. And so thank you very much for the opportunity to engage with you.
Thanks so much, Bob, for being here, for sharing your personal story, your family story, for all of the inspiring words, and for the much needed history lesson. We really appreciate it. You've given us quite a lot to think about, particularly as it relates to the experiences of Asian American people and families in this country, and all of the nefarious ways in which the law has worked to the detriment of all manner of Asian American communities throughout this country's history. And thank you again for all of the incredible work you've done on behalf of people and communities of color, and for continuing to agitate for racial justice at every turn. Thank you so much. I also want to again thank Dr. Janet Bell for her vision in putting this lecture series together so many years ago, and giving all of us the opportunity to gather on an annual basis and reflect on the myriad ways in which critical race theory and Professor Bell's work more generally continues to inform our collective effort to identify, expose, and push back against racism and oppression wherever and whenever it may arise. So thank you again, Dr. Bell. So on behalf of NYU School of Law and the Center on Race and Equality in the Law, I want to thank everyone again for joining us, and we look forward to reconvening next year. In the meantime, stay inspired and keep fighting the good fight. Thanks, everybody.